Hi everyone, and welcome to our webinar on enforcement of judgments in civil and commercial matters, a global comparison. My name is Donna Newman and I'm a partner in commercial litigation in the London office at Stephenson Harwood. Last year, I agreed to be the editor of the Legal 500 Comparative Guide on Enforcement of Judgments, which has been an absolute pleasure because it's a great guide and I got to work with all these wonderful people who you are going to see today. I believe that someone is going to post the link to the guide in the chat, so please do have a look at it, save it to your favourites for future reference. As we know, enforcement of judgments is a really key topic. Obviously, we spend time at the outset of a case thinking about the merits of a claim, whether it will be possible to obtain a judgment. It is equally, if not more important, to consider whether your judgment is really going to mean anything. After potentially years of hard work, not to mention the costs, are you going to be able to enforce it where you need to? Are you going to get paid? Today, we are presenting to you the people and the ideas that can help you answer this question. We are going to hear from 18 different law firms on enforcement of judgments in their jurisdiction. I feel very lucky to have spent time with these people over the last few weeks, because not only do they have some very insightful things to tell you about enforcement in their jurisdiction, but they are also very nice and easy to work with. So please do get in touch with them when you need help in their jurisdiction or with any questions after the webinar. I'm afraid that we have so much to squeeze in today that we don't have time to do a live Q&A. When I was planning this webinar, I added up all the time slots and realised that I had done such a good job of cramming in lots of brilliant content that I hadn't really left any time for myself to do much of an opening. So you will just have to take it from me that my longer opening would have been absolutely brilliant and or delivered at super speed. In the time we have available, we are going to hear from 4 different groups, which I've called Europe EU, Europe non-EU, offshore and rest of the world, which will include China, Mexico and UAE at the end. I'm going to ask the Europe EU group to come forward first by turning on their cameras and say hello to you all. In this group, we have Belgium, Cyprus, Finland, France, Germany, Greece, Italy, and Sweden. And I'm going to ask Belgium to unmute, say hello, and go first.
Thank you, Donna. Can you hear me? Okay, perfect. Hello, everyone. I'm Charles de Bertaert, and I work as counsel at Janson, which is a Belgian full-service independent law firm, and I work in its dispute resolution practice. So today I will be talking about the enforcement of foreign judgments in civil and commercial matters under Belgian law. Now, as Belgium is a EU member state, a distinction needs to be made between enforcing EU judgments and non-EU judgments. For EU judgments, we mainly need to look at the EU regulation on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. Other regulations may also come into play, but that would surpass the scope of this rather high-level summary that we're having today. So basically, and in summary, as Belgium is a EU member state, which implies that judgments rendered in the EU are recognized and enforceable unless they meet any grounds for refusal as laid down in the EU regulation. Now, such grounds for refusal can, for example, be in case that it would be incompatible with public order, or if it would conflict with the exclusive jurisdiction of another member state. The procedure of enforcement is therefore relatively straightforward, and of course does imply some basic administrative steps. Now, moving on to the foreign judgments from non-EU member states, it should be noted that Belgium's Code of Private International Law applies, save, of course, if international treaties and conventions apply, as they supersede Belgium's Code of Private International Law, which is national legislation. So in other words, for judgments rendered outside of EU member states, the relevant grounds for refusal will be set out in the applicable bi or multilateral treaties, or in the absence thereof by Belgium's Code of Private International Law. Now, examples of grounds for refusal are, here again, if it would be incompatible with public policy, if there would be like a violation of the rights of defense, or, for example, if the Belgian court had exclusive jurisdiction to hear the claim. Now, for the enforcement of outside EU judgments to which the Belgian Code of Private International Law applies, a Belgian judge must declare that the foreign judgment is enforceable. Such enforcement procedure does not include a review of the grounds or the merits of the claim or the matter, but the Belgian judge will on the other hand need to verify whether the foreign judgment's enforcement would infringe any grounds for refusal, as mentioned before. So here again, also some administrative steps must be undertaken, such as obtaining a certified copy of the foreign judgment. What is also noteworthy is that under Belgian law, the limitation period of a judgment is 10 years, with a maximum of 30 years after extension. But of course, you need to be cautious about the first 10 years if you want to trigger any extension after that. As regards costs, the applicant should take into account around 350 euros in terms of bailiff fees and court fees. As regards lawyers' fees, that will obviously depend on the arrangements that you have with your local council here in Belgium, but you should at least take into consideration about 1,500 euros. But then again, that depends on the arrangement that you have with your lawyer. So as we're quite limited in time, I'm of course happy to discuss further queries, and you can reach out to me on the contact details that were circulated. So thank you very much, and I believe I'm just in time. Thank you.
Thank you. That was great, and thanks for keeping to your time. I'm going to move straight on to Cyprus, please.
Hello, everyone. Greetings from Cyprus. My name is Alexandros Gavrielidis, and I am a partner at Skordis Papapetrou & Co. LLC. Now, Cyprus is a common law jurisdiction and also a member state of the European Union. Consequently, judgments given by the courts of other EU member states in civil and commercial matters are enforceable in Cyprus pursuant to the provisions of the Brussels regulation on jurisdiction and enforcement of judgments, to which Charles has just referred. Judgments given by the courts of Norway, Switzerland, and Iceland are enforceable in Cyprus pursuant to the provisions of the Lugano Convention, which are similar to the provisions of the Brussels regulation. And judgments given by the courts of other states may, in the absence of any applicable bilateral or international convention, be enforced in Cyprus by bringing an action at common law on the basis of the foreign judgment. Now, judgments given in the UK, provided that they are final and conclusive and for a definite sum, continue to be enforceable in Cyprus post-Brexit, pursuant to the provisions of Cypriot national legislation, which provides for the enforcement in Cyprus of judgments given by the courts of certain other Commonwealth countries. Now, given that the EU has opposed and continues to oppose the UK's accession to the Lugano Convention, this is particularly important, as Cyprus is currently one of the few EU member states where UK judgments continue to be enforceable. Now, in addition, Cyprus has bilateral treaties providing for the mutual recognition and enforcement of judgments with many non-EU member states, including Russia, China, Ukraine, Georgia, Belarus, Montenegro, Serbia, and Egypt. So most foreign judgments given in civil and commercial cases may, in principle, be enforced in Cyprus, subject, of course, to the conditions and exceptions set out in the applicable treaties, or in the case of common law enforcement, the established grounds on which recognition of a foreign judgment may be resisted, such as lack of jurisdiction of the foreign court, fraud, breach of a jurisdiction agreement, breach of the principles of natural justice, public policy, etc. Now, pursuant to the provisions of the Brussels regulation, a judgment creditor who has obtained a judgment from the courts of another EU member state is entitled to proceed directly with enforcing the judgment in Cyprus using one of the methods of enforcement that are available under Cypriot law. By contrast, judgments given by the courts of non-EU member states are first required to be recognized and registered before any measures of enforcement can be taken. Unfortunately, the enforcement process in Cyprus is often long and slow moving, especially in cases where prior recognition or registration of the judgment is required. In such cases, the enforcement process may take several months, and in extreme cases, up to 3 years or longer, depending on the conduct of the judgment debtor. This is because there is no summary procedure for enforcing a foreign judgment, and all applications relating to the enforcement, apart from applications for urgent interim relief, are required to be served on the judgment creditor, who has the right to oppose the applications, even in cases where it is clear that there are no valid grounds for resisting enforcement. And the long duration of the enforcement process gives considerable opportunity to judgment debtors to dissipate or remove their assets from Cyprus in order to frustrate enforcement. This is why obtaining effective interim relief pending the enforcement of a foreign judgment is particularly important in Cyprus, as is the identification of the most suitable form of interim relief, depending on the nature of the judgment debtor's assets in Cyprus. Indeed, one of the main advantages of Cyprus as a jurisdiction for enforcing foreign judgments is the availability of a wide range of effective interim relief measures, which may be obtained relatively quickly and often without notice to the judgment debtor, especially in cases where the judgment creditor acts promptly. Of course, applying for interim relief in aid of enforcement is costly, and judgment creditors trying to recover relatively small amounts may well find the costs to be disproportionate. In Cyprus, this problem is particularly acute because the costs that are awarded by the Cypriot courts in favor of the judgment creditor and against the judgment debtor, if enforcement is successful, are low and often represent only a fraction of the judgment creditor's actual costs. This being said, in our experience, the costs incurred for the purpose of securing effective interim relief very often prove to be a good investment for the judgment creditor, as they significantly improve the chances of successful enforcement. All things considered, and despite the problems I described, Cyprus is a good jurisdiction for enforcing foreign judgments, so long as the judgment creditor acts promptly and appoints experienced lawyers with expertise in this area, who will be in a position both to obtain the right kind of interim relief and deal with any delayed tactics on the part of the judgment debtor. Thank you very much.
Thank you very much. Moving straight on to Finland.
Oh, hello, everybody. I would have liked to have a lot of snow behind me, but unfortunately we had these ideas of looking alike. But in addition to snow, I would like to talk to you about the Finnish entities. My name is Ville Salonen, and I'm partner at the Attorneys at Law Magnusson in Finland. We actually have offices in the Baltics and in the Nordics, and I will have my Swedish colleague also speaking up in a while. And since we represent both of the countries, I have to say that we have a lot of cross-border experience in this kind of situations, and you can read much more about us in the article that Donna mentioned in the beginning. And without repeating what has already been said, I can just say that as an EU state, the EU enforcement procedure is pretty much straightforward and in accordance with what was already explained by the colleagues ahead of me. I have to say that in practice in Finland, in order to be able to proceed with the enforcement procedure, you would have to have a local counsel because of the language questions. It's just so much easier to get things done when you have somebody who speaks fluent Finnish, which is not that common outside of our borders. And then within the EU judgments, there is also the possibility of enforcement appeals, which I will mention later on. As the second point, which is perhaps something that should also be known not only by lawyers dealing with enforcements and disputes, but also dealing with lawyers who are dealing with agreements and actually writing them when you have a Finnish counterparty in the deal. And that is that, as the general rule of us is that the foreign judgments are not recognized unless there is some specific ground to grant enforceability, which is then of course Brussels Convention or Lugano Convention, which were already mentioned. And also I have to say that New York Convention of Arbitral Awards is of course valid in Finland. And where this results is that to enforce a judgment issued in some other countries, you need to have either bilingual agreement between those two countries, or you would have to have you would have to go through a specific court procedure in Finland. So if you have legal support on enforcement by the ways of Lugano Convention, for example, there is a straightforward application in the district court just to guarantee the enforceability of the decision. Of course, normal refusal arguments, as has been already mentioned before, apply to those, but normally it is quite a straightforward procedure. However, if you are dealing with a country that is not having an agreement with Finland at the moment, UK is one of those examples, is that you would have to actually open up a court case. And of course, the foreign judgment is just a written proof and a written evidence in the court case and might have a lot of value in the actual case, but it doesn't guarantee that it's anyways a slower procedure, it's a more costly procedure, and of course it gives the other side a lot of possibilities in objecting. So at the end of the day, for example, if you have a commercial agreement with a Finnish counterparty, you may consider that perhaps arbitration clause would be a practical one, not only for dealing with the actual dispute in a quicker and confidential way, but also in a way of guaranteeing a simpler enforcement procedure. And that is perhaps something which is quite unique for us here. Then once you have this enforcement decision, whether or not it's a result of an EU ratification or a treaty-based ratification procedure or a separate procedure, you need to apply for enforcement. And we have a system where even in the enforcement procedure, a creditor can make an enforcement appeal. And this kind of enforcement appeals can cause delays and also need for legal assistance in Finland. And if you already have a local counsel making the applications in the first hand, as was mentioned by the Cyprus colleague just a minute ago, it would also help you here in Finland. More information can be found in the article, and I think I have just used my time. So thank you all.
Thank you very much. Brilliant timekeeping. Moving on to France. Pierre, we can't hear you. I think you've unmuted, but we haven't got sound from you. If okay with you, I am going to skip on to Germany, and you can see if you can work your sound out in the background. Dominic, are you okay to go now? Brilliant.
Yeah, Donna, of course, I can step in. So thank you very much so far. My name is Dominic Stier. I'm a local partner at White & Case, and I'm very happy to give you a brief overview over the requirement and procedure to enforce foreign judgments in Germany. In my presentation, I will only touch upon additional. I will not touch upon EU law. That means the Brussels regulation and the Lugano Convention. I will only touch upon the requirements or refusal grounds that apply additionally if we don't have an EU judgment. There are three further requirements or refusal grounds which I would like to point out. So for a non-EU judgments or non-Lugano judgments, you need a final and a binding judgment. It's pretty clear what that means. So the judgment should not be subjected to legal remedies anymore. A further requirement is there is to some extent a review of the competence of the court of origin where the judgment was issued. That means that for enforcing a foreign judgment, the German court will consider whether the court of the country of origin would have jurisdiction if the rules of the German Code of Civil Procedure applied. So this is also called a reflection principle. This sounds difficult, but this hurdle will be always easy to overcome, actually, since the jurisdiction rules are quite similar internationally. A further requirement is that the reciprocity must be guaranteed between Germany and the state of origin. That means under German law, reciprocity is guaranteed if taking into account the mutual law and practice, the requirements for recognition of German judgments in the country of origin are essentially equivalent as vice versa. Reciprocity is of course is guaranteed if there is a bilateral treaty. If such treaty is absent, it is on the court to determine the practice, the recognition practice. So, for example, with regards to the US, reciprocity is basically granted, but it should be examined to each state of the US. The UK, it's difficult now due to Brexit, but it's generally assumed that it's reciprocity is at least granted to payment judgments issued in the UK. Also, for example, reciprocity is guaranteed to Japan or to Brazil. By contrast, reciprocity is not deemed granted with regards to Saudi Arabia, UAE, also Thailand and Indonesia. With China, it's disputed. There's a recent court decision denying reciprocity with regards to China. Only a short overview over the procedure. If you have a non-EU, non-Lugano judgment, you need to obtain a so-called exequatur judgment. So within an ordinary proceeding, that means the German court will declare or must declare the foreign judgment enforceable in Germany, the exequatur judgment. For this, the local jurisdiction lies within lies at the seat of the court where the defendant is seated or has its assets. Also, since it's a regular proceedings, oral hearing will take place. And yeah, after a final judgment is obtained, the judgment is also subjected to appeal and also probably the second appeal might apply. Competent will be the regional court in most cases. Further, it has to consider that the proceedings with regards to, or to obtain an exequatur judgment with regard to non-EU, non-Lugano judgments can take a considerable long time. The problem is that the German court has to deal with issues of foreign law, especially with regards to the reciprocity. So, for example, with regards to the recognition practice, the court will obtain an expert opinion on the issues of the foreign law, and that will significantly delay the proceeding. So thank you very much for your attention.
Thank you very much, and delivered with a beautiful picture of Germany in the background.
Thanks.
Can we try France again? Is your sound fixed?
Yeah, sorry. Can you hear me now?
Yeah, got you. Well done.
Okay, sorry everyone. Hello, I am Pierre Linnet from the law firm Jantet, which is based in Paris. And as you may have guessed already, I will talk about the French legal system. The idea is not to give you a detailed presentation of all of the rules that apply in France. I will try to highlight the key points and practical things maybe to bear in mind when you want to enforce a judgment in France. First, what I want to say is that we have proceedings to enforce judgments in France that work pretty well. It is usually quick and not that expensive to obtain a decision declaring enforceable a foreign judgment. To be honest, I think that the hardest part of the game is often to identify the relevant assets and then to properly enforce your title. So first thing to have in mind with regards to the legal framework, France is a member state of the EU. So all of the EU regulation, which my colleagues have mentioned, apply. Judgments rendered in a member state are directly enforceable in France without any further procedure. In addition, France is party to a great number of conventions, the Lugano Convention that has already been mentioned, the Hague Convention of June 2005. France is party to a huge number of bilateral and multilateral treaties with a lot of countries. And of course, when we don't have applicable convention, French general law governs the enforcement of the judgment. All of these legal instruments provide for different rules, which I'm not going to describe here. But what we need to bear in mind, first, in terms of timing, it usually takes from 2 to 12 months to obtain a decision that declares a judgment enforceable, which is, I think, quick. Of course, it depends on the magnitude of the case and on the behavior of the other party. During the process, it is possible to obtain interim reliefs while the enforcement takes place. French courts are not entitled to reconsider the merits of the judgment, and you can, of course, appeal a decision which declare enforceable a foreign judgment. Important point, because I don't think it is the case everywhere, but you can enforce in France judgments against the debtors of your debtors. Last point, maybe costs. The losing party of an enforcement procedure may be ordered to pay a certain amount of the claimant's legal costs. However, what you have to bear in mind is that the costs that are awarded by the courts are usually much lower than the costs effectively incurred by the parties. That being said, the cost of the procedure are often lower in France than those that you can have in certain countries. I started this short presentation by saying that we have a process that works very well in France to enforce foreign judgments. Just think about it. If your debtor or the debtor of your debtor do has assets here.
Thank you very much. I feel a bit like a Eurovision host, which I'm enjoying. Next is Greece.
Hello all. Hi, Donna.
Hi.
I'm Elena Kosena. I'm a partner in Sublegal Papadimitri law firm, which is based in Athens. Similarly to other European countries, an EU civil and commercial judgment is directly enforceable in Greece by virtue of EU legislation, the most important of which is Brussels Recast Regulation. Foreign judgment may also be declared enforceable based on the provisions of international treaties ratified by Greece or EU. As my colleague said, this is the Lugano Convention, Hague Convention of 2005, but also by one of the 17 bilateral conventions on judicial assistance, which Greece has signed with other countries, including China, Russia, Ukraine, Lebanon, etc. Where the foreign judgment comes from a non-EU country or from a country with respect to which an international or bilateral treaty does not apply, the foreign judgment may still be declared enforceable in Greece under the requirements and through the procedure provided by the domestic Greek procedural rules. This procedure involves the issuance of a court judgment, which, when it becomes final, consists an enforceable title, enabling the beneficiary to request compliance with the debtor by means of enforcement. The proceedings that may lead to the issuance of such court judgment begin with an application of the interested party to the competent Greek court. The hearing of the application is likely to be fixed within a month from filing. The defendant should be invited by the claimant to attend the hearing. At the hearing, the applicant should submit to court evidence that all requirements of law concerning the declaration of enforceability are met. This includes proper evidence, mainly with regards to the enforceability of the foreign judgment in accordance to the laws of the state of origin, the jurisdiction of the foreign court, the non-breach of defendant rights of defense, and the lack of existence of a contrary final Greek court judgment issued in the same dispute and between the same parties. The Greek court is not allowed to reconsider the merits of the case, but declaration of enforceability will be denied in case the Greek court finds that the foreign judgment is contrary to Greek boni moris ethics or public order. This last requirement has led in the past to refusal to recognition to foreign judgments, usually coming from the UK, by which punitive damages or costs were adjudicated. However, the Supreme Court has recently adopted a different approach by judging that such foreign judgments are not opposed to the Greek public order, as long as the punitive damages or costs are not excessive. Although proceedings leading to a first instance court judgment may be relatively quick, it is true that the whole process leading finally to enforcement may be lengthy, in fact, lasts several years, in case the defendant decides to file an appeal or oppositions. For this reason, it is suggested that the claimant also considers filing separate proceedings against the debtor, by which interim relief, usually in the form of freeze of assets, is requested, similarly to other jurisdictions, like my Cypriot colleague said. It may be of interest to say that such interim relief could be granted, provided that the court finds that there is urgency, either during the proceedings for declaration and enforcement, or even before these proceedings start, being thus a useful tool for the security of the claim and of the amount awarded by the foreign judgment. I hope it was a useful summary, but please free to contact me for any clarifications needed.
Thank you very much. That was really interesting. On to Italy.
Hello, everyone. Thank you for joining this webinar. My name is Alessandro Gravante. I'm a senior partner and head of the litigation team at Giambrone in Italy. Our firm is an international law firm with 6 offices in Italy, in Milan, Rome, Naples, Palermo, Catania, and Sassari. We also have offices in the UK, in Spain, in Portugal, in France, and in Tunisia, and we recently opened the Japanese desk. So our main practice is cross-border litigation, and of course, a part of this is the recognition and enforcement of foreign judgments. As my colleague said, of course, Italy is a part of a EU community. That means that EU regulation applies. That is a very easy procedure that has been already dealt with. And in respect to non-EU judgments, our main law is the international private law, which is backdated in 1995, which Article 64 lays down the principle and the condition by which a foreign judgment can be enforced and recognized and enforced in Italy. The competent court is the Court of Appeal, that is normally in our system the second instance court, but sometimes has jurisdiction in some cases like the recognition of foreign judgments. Article 64 is similar to the EU regulation. The principles are the same. And what I would like to focus on is, like in Greece, in the recent years, there has been a change in respect to punitive damages in Italy that are typical of the American system, or in general of the common law countries. In respect to punitive damages, we know that they have a function to punish the party who acted with malice or by gross negligence. And until a few years ago, this was considered, punitive damages were considered contrary to the public order in Italy. So we had a lot of judgments, even from the Supreme Court in Italy, that refused to recognize or to enforce the foreign judgments containing punitive damages. This is because under the Italian system, compensation of damages was strictly related to the compensation of patrimonial damages or non-patrimonial damages for tort or negligence under some circumstances. In the recent years, as I was saying, there was a big debate in the doctrine that led the Supreme Court to give some opening to the recognition and to the system of punitive damages in Italy. And the first judgment was in 2015, where the Supreme Court stated that under an Italian point of view, the restoration of damages could be also something different from the patrimonial or non-patrimonial. And after this debate, the United Section of the Supreme Court in Italy, that is the special section of the Supreme Court that deals with contradictory judgments between the Supreme Courts, issued a judgment in July 2017, where it's been stated that it is possible to admit the existence of punitive damages also in Italy, and open it to the possibility to recognize and enforce a foreign judgment containing punitive damages under strict circumstances. It is not an automatic procedure, but the court has to take into consideration the foreign law in respect to the possibility that damages must be certain, and there is not possible to recognize a damages penalty if this is out of any specific rule in the foreign country. In respect to this, in respect to civil and commercial damages, commercial judgments, our firm also has been dealing with the family decision to be recognized and enforced in Italy, and a part of this are the special guardianship orders issued mainly from the UK courts in order to the child placement in Italy. Thank you, everyone. For more information, of course, feel free to contact us with our email. Thank you.
Thank you very much. And to the last member of our EU group, which is Sweden.
Thank you, Donna. Yeah, it's always a bit difficult to be the last one because people tend to forget or tend to be a bit tired. But the good part is that in a EU group like this, I think most things of relevance has been said. And when it comes to EU, Sweden has no reservations to any of the EU legislation on the subject. So it's quite easy also in relation to, the same applies also in relation to the Lugano Convention. The tricky part is if you are outside of EU, because it's the same as Willem, my partner, told you earlier, that if there is no applicable treaty or no specific, that is actually, in such cases, actually not possible to enforce a judgment in Sweden. So outside of EU and outside of EFTA, it's a bit difficult many times. And in this regard, we have the new development with the Hague Choice of Court Convention. That convention is actually ratified by Sweden, and that will makes it at least a bit easier to enforce a judgment in Sweden, which is not EU or EFTA judgment. But as long as you can get in here, when it comes to timing, it's quite easy. I would say it takes usually a couple of months to go through the process, at least if the decision is not appealed on by the debtor. In such case, I would say it's still quite fast, and I would say, at least in my experience, it takes about a year, perhaps a little more, to go through that kind of process. And in relation to costs, if that happens, the party who loses will have to pay the other party's fees for legal costs for legal counsel, etc. So that means that if the debtor is challenging the award, he or she takes a risk because he or she will have to pay if the court does not change the decision, which is the usual thing that happens. And when it comes to other fees, court fees and fees for the Swedish Enforcement Authority, those are quite small and minor ones. So you really don't have to bother about those. In relation to this, I could say that third-party funding is perfectly fine in relation to enforcement of judgment in Sweden as well. One thing which might be of relevance, at least for some jurisdiction, is that there is no limits for recognizing and enforcing a judgment which consists of ordering impunity or multiple damages, which might be the case in some jurisdictions, but there's actually no problem to enforce such a judgment in Sweden. And when it comes to limitation period, the limitation period is 10 years, and this can be extended by giving notice to the debtor, and there's actually no limit, so you can do this over and over again. It's quite easy also in relation to verify the judgment. Usually you don't need an apostille judgment, but a certified copy is good enough to show for the Swedish courts. And I think that pretty much sums up the few points I had. Thank you.
Thank you very much. Thank you very much to our EU group for all those presentations. Obviously lots of similarities between those EU countries, but also lots of important differences. If I could ask the EU group now to turn off your cameras, most of you have got your cameras off already, and then our next group is Europe, non-EU and Ireland. I'm going to stay politically neutral and not explain how disappointed I am that England and Wales is appearing in this group. Also to note that Ireland has kindly agreed to keep us company in this group because of the close connection with England and Wales. We do know that Ireland has made the decision to stay in the EU. So first is England and Wales.
Thanks, Donna. Hi, my name's Chris Pettit, and I'm a managing associate in the commercial litigation team at Stephenson Harwood in London. I'm also one of the co-authors of the England and Wales chapter of the Legal 500 Guide on the enforcement of judgments in civil and commercial matters. Obviously, it's not possible to go through all the detail of the enforcement regime in the short space available, so I thought I'd highlight some points of interest and try to draw together some common themes that run through the enforcement regime in this jurisdiction. One thing that might jump out from reading the England and Wales chapter of the guide is the number of different regimes that exist in this jurisdiction. Although Brussels and Lugano are no more, at least for judgments arising out of proceedings that postdate January 2021, we still have the Administration of Justice Act 1920 for judgments from certain Commonwealth states and British overseas territories, the Foreign Judgments Reciprocal Enforcement Act 1933 for judgments from countries with which the UK has a reciprocal enforcement treaty, the Hague Convention on Choice of Court Agreements 2005, where there's a qualifying exclusive jurisdiction clause in favour of the courts of one of the contracting states. That's the UK, EU, Mexico, Singapore, and Montenegro. The Civil Jurisdiction and Judgments Act 1982 for judgments from Scotland and Northern Ireland, and in all other cases we have the common law. And notwithstanding the number of different regimes, there is a reasonable amount of overlap between them. For example, generally speaking, whichever regime applies, judgments in this jurisdiction will not be enforced where they were obtained by fraud, where enforcement will be contrary to public policy, where the foreign court acted without jurisdiction, and where the defendant had insufficient notice of the foreign proceedings in order to defend them. Also, whilst there's no prohibition on the enforcement of judgments for punitive damages per se, manifestly excessive damages that do not merely compensate a party for its losses are likely to be considered contrary to public policy. And we do have a statutory prohibition on the enforcement of judgments for multiple damages. Another point to highlight is that, as a general rule, the English court will not examine the merits of the decision of the foreign court. There are, however, some differences between the regimes which can be a trap for the unwary. For example, the registration of a judgment under the Administration of Justice Act 1920 must be set aside where an appeal is intimated or pending in the foreign court of origin, but there's no such provision under any of the other regimes. The AJA, FJA, and the common law regimes also only permit the enforcement of money judgments, whereas non-money judgments can be enforced under the 2005 Hague Convention. Another key theme are the changes brought about by Brexit. Whereas one could previously, in most cases, look to the recast Brussels regime for the enforcement of any EU judgment in a civil and commercial matter, different rules will now apply depending on the origin of the judgment and its nature. For example, it could be the 2005 Hague Convention, where there's a qualifying jurisdiction clause. It might be the Administration of Justice Act 1920, in the case of judgments from Cyprus and Malta. It might be the Foreign Judgment Reciprocal Enforcement Act 1933, in the case of judgments from Austria, Belgium, France, Germany, Italy, and the Netherlands, although opinions do differ as to whether the relevant bilateral treaties have been revived following Brexit, or if none of those apply, it will be the common law. Looking to the future, hopes had originally been pinned on the UK acceding to the Lugano Convention post-Brexit, but that no longer appears likely, at least in the near future. Instead, it may be that the future lies in the 2019 Hague Judgments Convention, which the EU ratified in August 2022. On 15th of December last year, the UK government launched a consultation on the UK's concession to the 2019 convention. And if the UK were to accede to the 2019 convention, it would certainly go some way to remedying some of the confusion brought about by Brexit. It would also increase the circumstances in which non-money judgments can be enforced in this jurisdiction. However, whilst it's broader in its application than the 2005 Hague Convention, it's not a complete jurisdictional code, unlike Brussels and Lugano. But anyway, for now, it remains a case of watch this space. Whilst not strictly an enforcement decision, I just want to finish off by briefly mentioning the commercial court decision from last November in Ebury Partners Belgium and Technical Touch BV. In this case, the defendant had issued proceedings in Belgium, notwithstanding the existence of an exclusive jurisdiction clause in favour of England. The claimant sought and obtained an anti-suit injunction from the English court, restraining the defendant from pursuing the Belgian proceedings. In the circumstances of the case, it wasn't necessary for the court to decide whether the 2005 Hague Convention was applicable, although it seems reasonable to assume that it would have been. Under Brussels recast, which would have applied if the proceedings had predated Brexit, it would not have been possible to obtain anti-suit relief from the English court. Prior to Brexit, there'd been a degree of speculation about whether we would see the return of anti-suit relief in the European context, and that question now appears to have been settled. It's going to be very difficult to enforce a foreign judgment in England where the foreign proceedings in question are in breach of an English anti-suit injunction. And that's why I thought it was a decision worth mentioning in the enforcement context. But anyway, that's all I had to say. So Thank you.
Thank you, Chris. Clearly, things have got a lot more tricky in England and Wales since Brexit, and litigants are going to need a real expert like Chris to help them navigate all of that. Thank you. Next to Ireland.
Thank you, Donna. Larry Fenlon here. I'm the head of dispute resolution in Ogier Le Mans, which is the Irish arm of Ogier. Ireland is, of course, an EU member state, as clarified by Donna. Although we're the only remaining common law and English-speaking one, and given the impact of Brexit on its closest and largest trading partner, it's probably felt that we should be lumped into the rest of Europe category. Essentially, there's 4 ways to recognise and enforce a judgment in Ireland. The first is Brussels recast, which I think our EU colleagues have very clearly and repetitively set out that effectively, if you have judgment in one EU jurisdiction, it's automatically recognised in the other. And in Ireland, all you have to do is have a copy of the judgment, a certificate of origin, a translation, and fill out a form, and you're good to go. It's almost instantaneous, the recognition there. So it's really very simple. And there's no ability to review the substance of the judgment, or indeed to review the jurisdiction of the court of origin, and the courts in Ireland have to recognise it. It has a limitation period of 12 years. So that's the first way, is Brussels recast for those who are enforcing EU jurisdictions in Ireland. The second is Lugano, and of course this largely just affects Iceland, Norway and Switzerland, and therefore has limited application for the purpose of this talk. But there is an ex parte, or one-sided application that one has to make to the court. That's grounded on an affidavit in which various criteria has to be set out. It's largely procedural. It'll take 4 to 8 weeks, and there's no discretion to not recognise, if you like, where the proofs are in order. So then that's, I suppose, largely the second way. The third way of enforcing and recognising enforcing in Ireland is the Hague Convention. And I think there's 91 signatories to this, including the UK more recently. This only really applies where there's exclusive jurisdiction provisions in commercial contracts. So if there is a exclusive jurisdiction provision for English law and Welsh law, then that would be recognisable and enforceable in Ireland. However, the one thing that it doesn't allow, actually, the Hague Convention doesn't allow the recognition of interim or injunctive type of reliefs that are being sought, like a Moravian injunction or something like that, where you're looking to freeze the assets, where there's a fear of dissipation. So that's a real problem. But it's also a little bit more laborious. Again, there's an ex parte application, which is a one-sided application that has to be made before the court, setting out lots of specific criteria before the master of the High Court. It should take roughly 1 to 3 months, largely, to get that recognised, and then it's enforceable. Then the notice of enforcement order has to be served on the debtor, and then it can be enforced just like a domestic judgment. The fourth means of recognised enforcement is under common law, and as I stated at the outset, we are a common law jurisdiction just like the UK. The problem with recognising, let's say, a UK or a non-EU or non-Hague Convention type judgment in Ireland is that one has to start effectively legal proceedings at the outset. And in the Irish High Court, it's called summary proceedings, and you start with a one-sided application to serve outside the jurisdiction granted on an affidavit. So effectively, then you have to serve the debtor with a notice of a motion to recognise that judgment, and there's all sorts of messing can occur then, because of course the debtor can defend themselves. They're on notice, and it's a contested application effectively. On a good day, it'll take 3 to 6 months, but on a bad day, probably twice that. The difficulty is that the debtor can evade service of the motion. They can contest the application of the grounds that the judgment isn't for a definitive sum, it's not final and conclusive, or the court of origin lacked jurisdiction, or it breaches public policy, or it was obtained by fraud, or the Irish High Court lacks jurisdiction, or the judgment contradicts a previous jurisdiction. So it is a real problem, and it's very laborious, and it's no surprise that the UK were really pinning their hopes on being a Lugano Convention signatory, but that's not obviously possible at this juncture. Just one point I wanted to make in respect of Moravian injunctions. So these are interim injunctions to freeze assets of a party. It's threatening to dissipate those. Obviously, it's allowed under Brussels recast. It's allowed under the Lugano, but not under the Hague Convention. Just to note that, and it is allowed under common law. Under Irish law, there's a case of O'Mahony versus Horgan, and the applicant who's looking for that Moreva Frisian order has to have a set of grounds for believing there's a real risk of assets being removed or dissipated. For further information, feel free to contact me. That's all from me. Thank you, Donna.
Thank you very much for that comprehensive explanation. And straight on to Switzerland.
Thank you very much, Donna. My name is Daniele Favalli. I'm a partner at the co-head of the disputes practice at Fisher in Zurich, one of the larger commercial firms. And of course, now we have heard already the 10 different ways of how to enforce a judgment. I was trying to think, what should somebody outside of Switzerland know about enforcement of a judgment or an arbitral award that you haven't quite heard yet. And of course, Switzerland, as a small jurisdiction, is focusing and has a big focus on enforcement in general. So I'd like to bring you or to present to you a few perhaps different views on enforcement or enforcement-related issues. So you may agree with me that the importance of Switzerland's financial market led, among other things, to the stigmatized role of Swiss bankers in movies like James Bond's The World Is Not Enough in 1999, or DiCaprio Unforgotten in The Wolf of Wall Street in 2013. And of course, you'll then have those Swiss bankers and the role of those Swiss bankers appearing in those movies. So Switzerland continues to be quite an important place and venue for, and continues to be a hub for financial services. So there is a new 2022 study by the Asset Management Association and the Lucerne University of Applied Sciences that showed that an incredible amount of 3.3 trillion Swiss francs were managed in Switzerland in 2021. About 1.1 trillion are managed for contracting clients abroad. And another source held in 2022 that Swiss banks hold a net wealth of 8,830 billion Swiss francs on their accounts. So needless to say that, that this continues to be an important issue. One of the imminent problems about enforcement, obviously, is the risk that the debtor could hide assets before it comes to enforcement. And in Switzerland, like many other jurisdictions, the creditor may attach assets. In this context, I want to focus on, obviously, monetary claims and monetary judgments. And Switzerland perhaps plays a specific role in this environment. So Swiss debt enforcement and bankruptcy laws provide, hopefully, for an effective tool. And the one issue that you might be interested in is that for an attachment to be granted, a decision does not have to be final according to Swiss law. That will be Article 271, Section 6 of the Swiss DIBA, Debt Enforcement and Bankruptcy Act. So in other words, the creditor may request an attachment following a substantive decision of first instance. So it has not to be final. The position of a creditor may thereby improve significantly. And notably, the timeline for such an attachment in Switzerland is quite remarkably short. Ordinarily, an attachment may be granted within days or a few weeks at most, but we are rather in the few days section than the few weeks, which give you a competitive advantage, perhaps over other creditors, and it may come as a surprise effect to the debtor. Obviously, and having said that, one is to review on a case-by-case analysis whether and how easily a foreign judgment may be recognized in Switzerland. The analysis will, in essence, be along the lines presented by my colleagues and most of the other speakers that we have heard. Yet there are those differences between the categories, between EU decisions and obviously Lugano Convention decisions and other decisions that follow the Swiss Private International Law Act, or PILA. And but in essence, one can say that Switzerland is recognition friendly and is also quite friendly when it comes to secure a creditor's right, at least on a provisional basis, in order to make sure that assets that are available will be available after the ordinary enforcement process. For the sake of time, I will not address any further details in this regard, but I'm happy to answer questions bilaterally, and I thank you very much for your attention.
Thank you very much. That concludes the Europe, non-EU and Ireland group. So if you could all turn off your cameras, we are now going to move on to the offshore group. If members of the offshore group could turn their cameras on. And in this group, we are going to cover Bahamas, Cayman and BVI, Guernsey and Jersey. And I was going to ask Bahamas to go first, but they haven't got their camera on. Bahamas, are you with us?
We're here, but we're unable to turn our camera on.
Okay. Why don't you go ahead without your camera then?
Sure. So I'm Ryan Elliott, and I'm joined this afternoon by Trevor Lightbourne. We're both senior associates here at Higgs & Johnson in Nassau, the Bahamas. We practice in various areas of commercial disputes, including insolvency, asset recovery, and enforcement litigation. Regrettably, Tara Archer-Glasgow, the chair of our litigation practice group and co-author of the Bahamas chapter, could not join us today. We wish to outline a few key points to note when seeking to enforce foreign civil and commercial judgments in the Bahamas. Generally speaking, foreign judgments can be enforced in the Bahamas once recognized by an order of the Supreme Court. The enforcement of foreign judgments in the Bahamas is not subject to any international conventions or treaties. Therefore, foreign judgments may be enforced either by recognition and registration under local statute, or by commencing a claim at common law in the usual way. Foreign judgments obtained in certain scheduled jurisdictions may be registered under the Reciprocal Enforcement of Judgments Act 1924. These jurisdictions include Jamaica, Australia, and the UK. Importantly, enforcement by registration is not available in respect of judgments obtained in the US or Canada, but they may be enforced at common law. To be enforced, an order must be made by the Foreign Superior Court, and an application to register under the Act should be made within 12 months, although this period may be extended. The application may be made ex parte and is usually determined summarily. The Bahamian Court will consider whether it's just and convenient that the judgment should be enforced in the Bahamas, and registration under the Act may be opposed by the judgment debtor on various grounds, including, but not limited to, on the basis that the foreign court lacks substantive jurisdiction. Generally, an application for registration can be heard and determined within 12 months. Once registered, the foreign judgment is enforceable for a period of 6 years. An important point to note is that the Act was amended in 1999 to permit the registration of any judgment, replacing only money judgments. In a recent decision, the Bahamian Court considered the scope of judgments and orders capable of registration and enforcement in the Bahamas under the Act, particularly whether interlocutory relief, including foreign Moreva injunctions, may be registered under the Act. The decision highlighted the issue of freestanding injunctions, and the Supreme Court distinguished that the jurisdiction to register a foreign injunction is distinct from the jurisdiction to grant a freestanding injunction in aid of foreign proceedings. This area is still developing. Watch this space.
As Ryan mentioned, the Act is only applicable to certain jurisdictions. Foreign judgments emanating from countries outside the ambit of the Act may be enforced at common law by bringing an action against a judgment debtor, suing upon the foreign judgment in the usual way. Once the claim is issued against the judgment debtor, it must be served on the judgment debtor in the jurisdiction unless leave is obtained to serve the claim outside the jurisdiction in accordance with the rules of court. Generally, a foreign judgment will be ordered to be recognized once the foreign court had jurisdiction over the foreign judgment debtor, the enforcement is not contrary to public policy, and the proceedings in which the foreign judgment was obtained were not opposed to the rules of natural justice. Once the claim is served on the judgment debtor and it appears that there is no valid defense to the action, the judgment creditor may apply to dispose of the action via some interlocutory means, and the court will determine the application on affidavit evidence. If the judgment debtor raises an arguable defense, the claim will proceed to trial in the usual manner. In most cases, orders for the recognition or registration of foreign judgments may be appealed, and a judgment debtor may apply to set aside registration or for a stay of execution. Both interest and costs are recoverable, but as always, they are in the discretion of the court. However, we generally anticipate the court will, in the usual circumstances, order for costs to follow the event.
Thank you. If you have any questions, you can reach out to either Trevor or myself at Higgs & Johnson.
Thank you both. And we managed to get your camera on as well, so we did see you briefly. Straight on to Cayman and BVI.
Thanks, Donna. Hi, everybody. Thanks for staying with us. I'm Jeremy Sneed, a partner in OSIA's Cayman Dispute Resolution team, but based in London. I'll be moving this presentation slightly south in the Caribbean and briefly covering enforcement in the Cayman Islands, which I think is on my right, and the BVI, which is on my left, given there are similarities in the regimes. I hope I've got that map the right way around. Firstly, the good news, both Cayman and BVI have statutes that provide for recognition of foreign judgments of superior courts from an exhaustive list, although I don't think that these can take credit for ending the golden age of piracy in the region for reasons I won't go into today. In BVI, it's the Reciprocal Enforcement Judgments Act of 1922, and in Cayman, the Foreign Judgments Reciprocal Enforcement Act from 1996, so a few years later. The less good news is that both of these are very limited in relation to the jurisdictions to which those acts are extended. The BVI includes the courts of each of the UK countries, certain Caribbean jurisdictions, but importantly not the Cayman Islands, New South Wales and Nigeria. New South Wales appears to be a paragon of judicial virtue, as it also makes its way to the Cayman list, and I see it was on the Bahamian list as well, together with certain other superior courts of Australia and its external territories, but that's it currently. Cayman does not automatically recognise judgments from England, Wales, Scotland, or Northern Ireland, or the US. Both Cayman and BVI have significant Australian expatriate communities, which could explain the favourable treatment, but there's obviously a stronger connection to the UK, although we don't anticipate that list getting longer at any point soon. The silver lining is that both jurisdictions do permit enforcement of foreign judgments by way of the common law, commencing proceedings in our jurisdiction upon the foreign judgment. The reality is that process is not that much more limited in time than the process pursuant to the Acts, although the statutory process is slightly quicker. You're looking at a month for the statutory process instead of 3 to 4 months for the common law process. Although really the crucial timing for enforcement depends upon the mechanism that's then used to actually enforce the judgment. In fact, our common law recognition is broader even for those select jurisdictions, as the Acts only permits enforcement of debts or definite sums of money, whereas the common law enforcement will permit enforcement of certain non-monetary in personam judgments and does include judgments that are subject to appeal. Thankfully, enforcement of common law has been covered elsewhere in this talk. Crucial exemptions under Cayman and BVI law are the scope of the public policy to which we would not enforce judgments. These include penal or fiscal judgments and other judgments in relation to causes of action that would not be actionable in our jurisdictions. Neither of our courts will consider the merits of the underlying judgment. Additionally, the Cayman Islands has a statutory restriction in its Trusts Act that prohibits the recognition of any judgment that purports to invalidate any trust governed by Cayman Islands law or seeks to affect the disposition of property from that trust by reason of the foreign jurisdiction prohibiting or not recognizing the concept of a trust or avoiding such by way of heirship rights, contravention of foreign law, or foreign judicial or administrative action. In both Cayman and BVI, you can recover costs of obtaining enforcement, and private funding can be used to assist in the costs of the enforcement via the Private Funding of Legal Services Act 2020 in the Cayman Islands and judicial precedent in the BVI. In Cayman, you can enforce a judgment under either regime within 6 years of the date of the judgment becoming enforceable, absent fraud or concealment, which extends that deadline. In the BVI, for recognition, you've got to apply within 1 year, although judicial discretion is available, or commencement of proceedings within the common law has to be within 12 years, again, absent fraud or concealment, which could extend that time limit. Interim relief, including the ability to obtain disclosure or freezing relief in relation to assets of the defendant, is available in both of our jurisdictions, and once judgment is entered, it may be enforced in the same way as a local judgment. Thank you very much for your time. If you've got any questions, please do feel to reach out, and I'll refer the more detailed BVI queries to our extensive BVI team. Thank you very much.
Thank you, Jeremy. I realise I've asked quite a lot of everyone asking them to cover this topic in such a short period, and Jeremy's done 2 jurisdictions in his slot, so thank you very much. On to Guernsey.
Thanks very much, Donna. My name is Matthew Newman. I'm a partner and head of the dispute resolution team at OSIA in Guernsey. what I'm going to say is probably not going to be too dissimilar to what you've actually already heard from Jeremy in particular, but also from Larry in some ways, and actually from Chris for the UK. So just a bit of background on Guernsey for those of you who don't know. We are a small island in the English Channel, closer to France than the UK. We are normally described as an offshore jurisdiction. Many people have put their assets here and incorporated their companies here. We're never part of the EU, never have been at all. Never really been any taken part in any of the international treaties or conventions on enforcement of judgments. So we are in that respect fairly standalone. Now there are two ways of enforcing judgments in Guernsey. The first is under a piece of legislation called the Reciprocal Judgments Law from 1957, and there's some corresponding rules which go with that. And the second is under the common law, which Jeremy and indeed a few other people have already talked about. Now, the list of prescribed countries for our 1957 law is equally as obscure, I think, as those in the Caribbean. Although helpfully it does include the UK jurisdictions of England and Wales, Scotland, Northern Ireland, plus the Isle of Man and Jersey. But then slightly bizarrely, we also have Israel, the Netherlands, Italy, Curacao, St. Martin in the Caribbean, which is a Dutch territory, and Suriname. So there's obviously a link there with the Netherlands and its associated territories for reasons I don't quite know. Those are the only countries which can use the 1957 Reciprocal Judgments Law to enforce their judgments basically automatically in Guernsey. Everyone else has to use the common law. And there are some restrictions in terms of the 1957 law. First of all, it has to be a money judgment, so you can't enforce non-money judgments through that piece of legislation. That has to be done under the common law. And second, it has to be a judgment of a superior court. So, for example, if you're in England and you have a judgment from the English County Court, that isn't sufficient. You have to transfer that judgment up to the English High Court in order to make it registrable in Guernsey. There was a case about that, which I was involved in 2009, called Manchester and Interglobal, and it was confirmed that if you have an English County Court judgment, as long as you use a process to transfer it up, then you can use that in Guernsey, and I'm sure there are in all the other jurisdictions here present. There are going to be a system of hierarchy of courts, so you need to make sure that it's a particular court from one of those particular countries, and as long as it's a money judgment, then you can use the 1957 law. So relatively restrictive, but if you're in that, then it's actually quite simple. It's a notice of registration which you need to apply for. That is then served. If the judgment debtor is outside the jurisdiction, you need leave to serve on that judgment debtor outside the jurisdiction once a period of time has elapsed. And if the judgment debtor doesn't seek to challenge that notice for whatever reason, then the judgment takes effect as if it were a Guernsey judgment. Now, there are ways of challenging, and I think we've been through those in a number of the other talks just before, but obviously if it's not a final judgment, then it's challengeable. If it's not a money judgment, obviously it's challengeable. If it's from a court which doesn't have competent jurisdiction to hear the dispute, then it's challengeable. If it's from a court which is considered, to put it politely, from a corrupt jurisdiction, then again it's potentially challengeable as well. But if otherwise, it's a very swift process with one, perhaps two court hearings. It's then a Guernsey judgment, and you can enforce it accordingly over Guernsey citus assets. If you're going under the common law, which you would have to do if you're from any of the EU jurisdictions other than Italy and the Netherlands, or from the US, or from China or anywhere else, then what you need to do is you take your judgment debt and you sue on it under the common law. So you would need to start civil proceedings in Guernsey. That foreign judgment is the basis of your debt. If the judgment debtor is located outside of Guernsey, which is possible, then you need leave to serve out of a jurisdiction, and there are separate processes for that. But that can actually add to the time. So if you have a judgment debtor located, say, in the BVI, there's actually I think it's about 35 days that you need to allow between service and bringing the case back to court again to start the proceedings officially. So it can take some time. There are ways to challenge, again, that judgment. It's fairly similar to the categories I just mentioned, but essentially if you can seek to impeach that judgment in some way, then the court won't proceed. But the normal way then is to bring a summary judgment application, obtain a judgment, which then you have your own Guernsey judgment, which you can then sue, which you can then enforce again in the normal way. You have to do that within 6 years of obtaining your foreign judgment, so there's a limitation period of 6 years on that process. You can get litigation funding to fund your enforcement. This is becoming increasingly popular nowadays. There are a number of outfits which fund enforcement, as long as it doesn't offend the common law principles of championship and maintenance. Once the judgment is a Guernsey judgment, you can enforce it in the normal way. We use His Majesty's Sheriff, who's a court officer who will go and arrest assets for you and investigate and effectively get the assets for you on your behalf. To give you them back, you can seek an injunction, as Larry was talking about earlier, that we have a similar processes here, and you can also seek to enforce the judgment over real property in Guernsey if indeed the judgment debtor has any. So there's a whole gamut of enforcement processes available, and I think I'm just about done my time.
Thank you, and now a short trip across the water to Jersey.
Thank you, Donna. My name's Oliver Passmore, and I'm a partner in the dispute resolution team of Augier in Jersey, which is another small island in the Channel, slightly south of Guernsey. And I'll give you a very high-level overview of enforcement of foreign judgments in Jersey. I'll try not to repeat principles that we have in common with other offshore jurisdictions, but a lot of what I say will now be familiar to you, particularly having heard from Matthew. So, like Guernsey, Jersey is part of the British Isles, not part of the United Kingdom. It's a self-governing dependency of the British Crown. It's not a signatory to any international conventions or treaties in relation to the enforcement of foreign judgments, and it's not part of the EU. So in Jersey, like in Guernsey, you have two alternate routes depending on your jurisdiction. So if your judgment is from England and Wales, Scotland, Northern Ireland, the Isle of Man, or Guernsey, then you can take advantage of a procedure which applies for the registration of judgments of the higher courts in those jurisdictions, and that's governed by the Judgments Reciprocal Enforcement Jersey Law 1960, so 3 years after the Guernsey one. If the judgment's not from one of those jurisdictions, then you'll be reliant on enforcement at common law. So taking the statutory regime first, the foreign judgment or order must be final and conclusive between the parties, and it will be deemed to be final and conclusive, notwithstanding that an appeal may be pending, and it must be for a sum of money which is not in respect of taxes or other similar payments or in respect of a fine or other penalty. For the statutory regime, the judgment creditor must apply to the Royal Court to register the judgment, and the application may be made ex parte to the judicial greffier, who is an officer of the Royal Court. The application must be supported by an affidavit, which, among other things, will exhibit a certified copy of the judgment issued by the original court. Once the foreign judgment has been registered, notice in writing must be served on the judgment debtor, and that notice must state, among other things, that the judgment debtor's got a right to apply to set aside the judgment, and it must specify the time from the date of service of the notice that an application to set aside may be made. And a registered judgment may not be enforced until after the expiry of the period within which the application to set aside may be made. The process of registering and enforcing a foreign judgment in Jersey under the 1960 law is relatively quick and straightforward. In practice, we've seen that the application can be submitted to the judicial greffier in writing and determined on the papers. So the process, certainly for registration at any rate, could take as little as a week from submission of the papers, depending on the judicial greffier's availability. Although if they have questions or queries or require a hearing, the process could take longer. In terms of challenge, the Royal Court can set aside the registration if it's satisfied, among other things, that the foreign court had no jurisdiction to grant the judgment, that the judgment debtor didn't receive notice of the proceedings in sufficient time to enable them to defend them and they didn't appear, or if the foreign judgment was obtained by fraud, or if enforcement of the foreign judgment would be contrary to public policy in Jersey. At customary law, a foreign judgment has no direct operation, but can be enforceable by a claim or a counterclaim, i.e. you sue on the judgment. Now, it can be sued upon if it's a final judgment in personam for a liquidated sum of money, which is not in respect of taxes, fines, penalties, or other similar fiscal or revenue liabilities, provided that the court had jurisdiction to give the judgment was obtained without fraud, in accordance with the principles of natural justice, and is not contrary to public policy, and of course that the proceedings were properly served. The Royal Court has also said that it's got a discretion at customary law to be exercised cautiously to enforce foreign in personam non-money judgments given by courts of competent jurisdiction. Now, the way in which you do it is by commencing proceedings on the basis of the foreign judgment and seeking summary judgment without the Royal Court's reconsideration of the merits of the underlying cause of action. Proceedings would be commenced by way of an order of justice, which is an originating process usually for more complex claims, but a summary will be accepted, and it's usual to annex a copy of the judgment. So the order of justice will summons the judgment debtor to an initial hearing, and if they don't appear, then a default judgment can be obtained, and if they do, then it'll be put on a list of defended actions, and you can apply for summary judgment, and the timetable for that will depend on court availability. I think I should end there.
Well done. Big hint, me appearing on your screen. Yeah. Thank you very much, Offshore Group. That's great. Can I ask you to turn your cameras off now? And thank you to everyone for sticking with us. It's time for our headline act, which is rest of the world, China, Mexico, and UAE. And China is going to go first.
Thank you, Donna, for the introduction. And hi, everyone. This is Hua Chen from Global Law Office in Beijing, China. And I will briefly introduce a few key points relating to the subject under Chinese law. First and foremost, the application of foreign judgment enforcement under Chinese law is a two-step procedure. The applicant firstly needs to file an application at a court and obtain a favorable ruling declaring the judgment as registered and enforceable in China. Then an application for enforcement against respondent needs to be filed separately and subsequently. It will usually be filed at the same court which rendered the ruling of recognition, but not necessarily so, depending on factors such as the domicile of the respondent and the location of its properties, etc. Secondly, it's worth mentioning that the limitation period of the foreign judgment enforcement in China is 2 years, which is the same time limit for any domestic judgment. The 2-year time limit starts to run from the date judgment debt is due, and if the judgment debt is by installments, from the due date of the last installment. I understand the 2-year time limit is significantly shorter than the time limits in some of the other jurisdictions, which can be as long as 10 years. So for anyone considering enforcing foreign judgment in China, our suggestion is that act quickly and do not let the 2-year time period expire and impede your own rights. Thirdly, the decision rendered by the court is final and not subject to appeal in China. However, if an application is rejected and the applicant can initiate court proceedings in China on the merits of the claim against the respondent. Fourthly, another important issue regarding the legal grounds for enforcement. China, unlike some of the jurisdictions discussed, is currently not yet a party to any multilateral treaties on foreign judgment enforcement yet, and therefore the mechanism established under those treaties are not yet applicable to China. So how can a foreign judgment be enforced at a Chinese court? The PRC law provides a fork road option on this issue. If there are bilateral treaties between China and the foreign state concerned, the provisions in such treaty will apply. In the absence of a bilateral treaty, the PRC court shall review the application in accordance with the principle of reciprocity. And if the court determines that there exists reciprocal relations between China and the foreign state, the foreign judgment would be enforceable. Currently, some of the leading economies in the world, such as the UK and the US, have not yet signed agreements on judgment enforcement with China. It means that for applicants from these states and some others, reciprocity would be the legal ground to rely on. And in fact, some judgments from the UK and the US have recently been recognized at Chinese courts on the ground of reciprocity. Reciprocity as a legal concept is not defined under the PRC law. However, the Supreme People's Court does provide a non-binding guidance on this issue for the courts to follow. It provides that under any of the following three circumstances, the People's Court may find the existence of a reciprocal relation. First, judgments made by the People's Court are recognized and enforced by the court of the foreign jurisdiction. And second, China has reached a reciprocal understanding or consensus with the foreign jurisdiction concerned. Or thirdly, the two states have made a reciprocal commitment with each other through diplomatic channels, and no evidence shows the foreign court has refused to recognize or refused to enforce the judgments from China on the grounds that there is no reciprocal relation. The provision above suggests that PRC has been taking a generally quite flexible approach towards the interpretation and understanding of the reciprocity principle. But again, reciprocity is really an issue reviewed by the court on a case-by-case basis, and the court has the discretion over its interpretation and application. We are happy to discuss further if there is any question from the audience, and our contact information is available on the website of the Legal 500 Guide. Thank you.
Thank you very much. That was really interesting. Thank you. Moving straight on to Mexico.
Thank you very much. I am Hermes de la Rosa from Villar Abogados. We have offices in Mexico City and Querétaro. And well, regarding the enforcement of foreign judgments in Mexico, the main requirement for the Mexican state to enforce a foreign judgment is that such enforcement is not contrary to Mexico domestic law and that the judgment is final in its own country. Each request for enforcement of a foreign judgment in Mexican territory must be analyzed on a case-by-case basis in order to identify whether the Mexican state has a specific agreement or treaty applicable to the specific case with the country that issued the judgment to be enforced. As a general rule, it can be said that all foreign jurisdictional resolutions of a commercial or non-commercial nature are effective and will be recognized in Mexico in all matters that are not contrary to Mexican domestic law. This is the principal line to be followed here, that are not contrary to Mexican domestic law. As long as the resolution is final and it can be enforced in your own country, it will be accepted by Mexico, whether we do or do not have a specific agreement with your country. The first thing that must be done in order for a foreign judgment to be enforced in Mexican territory is for an authority within Mexico to declare the validity and feasibility of the enforcement of the foreign judgment. For such purpose, a special process called homologation of foreign judgment must be initiated before such authority, where the interested party must exhibit the resolution duly translated into Spanish and, if applicable, apostilled, explaining the motives and reasons why such judgment may be enforced within Mexico. For example, why does it not contravene Mexican domestic law? The authority has the obligation to issue a resolution approving or denying the homologation of the judgment. The homologation of the judgment, in order for the Mexican authority to recognize the validity and viability of the foreign judgment that is to be executed, it mainly follows that it does or does not contravene Mexican domestic law. The time to obtain a judgment homologation process is uncertain. It depends on the workload of each authority and the subject matter to the foreign judgment. It will not be the same, let's say, a commercial matter or a divorce settlement matter, which is usually considerable since Mexican courts take at least several months to manage each case. All trials require several months at best, sometimes years. The time that a judgment homologation, the main guidelines are that the Mexican state follows in order to recognize the application of judgments are for the following. First, the foreign law will be applied as it would be applied by the respective judge. Second, the foreign substantive law will be applied except when it is necessary to take into account on an exceptional basis the contradictory rules of said law and the substantive rules of the Mexican state. Third, it will not be an obstacle to the application of the foreign law that the law of the state does not provide for institutions or procedures essential for the applicable of the foreign institution, if analogous institution or procedures exist in Mexico. And four, when various aspects of the same legal relationships are regulated by different laws, these laws will be applied harmoniously, seeking to achieve the purpose pursued by each of them. As you can see, Mexico is a good jurisdiction for enforcing foreign judgments. Our courts are open for it. They do see it often, provided a clear case is prepared for the court to confirm. Thank you very much.
Thank you very much. That was great. And last but not least, it's UAE.
Thank you, Donna. Hi, everyone. Good morning or good afternoon, depending on where you're based. My name is Rana Musa. I'm an associate at Stephenson Harwood Dubai office and part of the commercial litigation and marine international trade teams. Given the time restraint today, I will focus on the main points of enforcing foreign judgments. The UAE is a civil law jurisdiction based on judicial cooperation. The most significant judicial cooperation that's signed by 18 Middle Eastern and North African countries and was ratified in the year 1999. The agreement of implementation of judicial decision that's signed by the Gulf Cooperation Council, the GCC countries, and ratified in 1996, as well the New York Convention on Arbitral Awards that was ratified in the year 2006, in addition to other conventions and treaties with different countries around the world. A very interesting update has recently been issued on reciprocity between UAE and English courts, where the UAE Ministry of Justice issued a circular directing UAE courts to apply the criteria that I will mention shortly when enforcing English court judgments. That is as a result of the English courts recently enforcing a UAE court before the English courts. That means that, of course, now the English courts issued will be easily, hopefully, applied here in the UAE when the criteria is available. As for the criteria, the UAE court should not have an exclusive jurisdiction to try the dispute. The state of origin must have jurisdiction to try the said dispute. The parties should have been served with the dispute and duly represented. The judgment does not contradict with the public policy and previously issued judgments by the UAE courts. And the judgment should also have gained the force of res judicata, meaning that it's final and appealable and enforceable in the country of origin. Generally, foreign monetary judgments can be applied in the UAE. However, non-monetary judgments, for example, ex parte judgments and orders for specific performance or injunctive reliefs, unfortunately cannot be applied in the UAE because the UAE in general do not issue such judgments here. As for the required documents, given the UAE is a UAE civil law jurisdiction, a power of attorney should be available, issued by the applicant to their lawyers and representative. The parties' identification documents should as well be submitted. For example, commercial licenses or passport copies as applicable for companies or individuals. The judgment is issued, a letter as well issued by the foreign courts confirming that the judgment is final, conclusive, and enforceable, and the document confirming that the party was served and duly represented. All these documents should be duly attested and translated into Arabic before being submitted with the enforcement application. In general, the UAE law will not consider the merits of the judgment. Neither do the UAE courts provide for a time limitation during which judgment should be enforced. As for the time limits or the time frame for enforcing such judgment, it's generally between 5 to 20 business days, of course, depending on the documents and information available and subject to all this information being provided along with the application. Once the judgment is issued, served upon the party, it can be challenged before the competent court of appeal, the court of appeal of jurisdiction, by the judgment debtor, during which normal appeal procedure will be taken, where parties will be allowed to defend and present their case. As for the cost for enforcing such judgments, it's really minimal. However, it depends. It's different between each local court and another. However, I would say that they don't exceed $1,500, $1,500 in general. That is it for the UAE. For more information, please refer to the article or feel free to reach out to myself or Rania Tadros, my colleague and office managing partner. Thank you.
Thank you very much. That's our last one. I'm going to invite all of the panelists to put their cameras on if they're still there, just to say goodbye and so we can see all your lovely faces. Thank you to all the panelists for all the hard work that you put into those presentations. I think we all appreciate how difficult it is to talk about something really complex in a really short space of time. And thank you to everyone who's joined us. We hope you enjoyed the webinar. Please do refer to the guide and get in touch with any of our panelists as you need to. I've seen a question in the Q&A asking about a recording. We have recorded the webinar and we're planning to make it available to everyone, so you shall be able to rewatch at your leisure. Thank you very much to everyone again. Goodbye.
Thank you.